Join us for the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation under God, indivisible, with liberty and justice for all. Good morning. This Tuesday, April 22nd, 2025. We'll start with our agenda. Is there any public input on the agenda, just the lineup itself? Okay, if not, can I get a motion to approve our agenda today?
So moved.
Thank you. Is there a second?
Second, Otten.
Thank you. Alicia, we call the roll.
Commissioner Aaron's?
Yes.
Otten?
Yes.
Schmidt?
Yes.
Putnam?
Yes.
Landine?
Yes, and then we'll move on to our consent agenda. Any public input on the consent agenda? If not, can I get a motion to approve?
Move for approval, Madam Chair.
Thank you. Is there a second?
Second, Otten.
Thank you. Got a motion and a second. Alicia, we call the roll?
Commissioner Aaron's?
Yes.
Otten?
Yes.
Schmidt?
Yes.
Putnam?
Yes.
Landine?
Yes, motion carries. Move on to regular business. The first item on our agenda is a second reading and public hearing for an ordinance of Lincoln County, South Dakota, amending Chapter 154, zoning, Section 154.021, definitions, Section 1.4.058, conditional uses, A1 agricultural district, Section 154.178, conditional uses, RC Recreation Conservation District, Section 154.254, additional use regulations, and Section 154.379A, notification for the regulation of carbon oxide pipelines, carbon oxide pump stations, carbon oxide mainline valves, carbon oxide capture facilities, and carbon oxide launcher and receiver facilities. The Planning Commission recommends approval 501. Toby Brown. Good morning, Toby.
Good morning, Madam Chair, Commissioners. Toby Brown, representing County Planning. Before you this morning is an ordinance. This is the second reading and a public hearing for an ordinance. Again, that was recommended by the Planning Commission. This was a result of the 5 remanded ordinances that the Board of Commissioners sent to the Planning Commission. They came up with this ordinance or recommend this ordinance. I'll go through kind of the higher level stuff of it. I'm sure the public can enlighten you more on some of the changes, but as well as you have any questions for staff after I'm done. So for the real substance of this, what this ordinance proposes to do is to utilize the existing neighborhood utility facility definition to modify that to exclude carbon oxide pipelines and above ground carbon oxide structures. The term carbon oxide takes in all the elements of carbon, carbon monoxide, carbon dioxide, so you're very familiar with, the terminology used to be carbon dioxide, but now this ordinance proposes to label it carbon oxide for the proposed uses or the land uses. So in terms of the land uses, again, the pipeline and the above ground structures, this ordinance proposed to make those conditional uses in the A1 agricultural district and in the RC Recreation Conservation District. Both of those districts are predominant zoning districts throughout the county. And typically, these types of facilities would be located within the predominant land use. The second item that would really get into is more kind of the meat of the issue, which is the setbacks. So what this ordinance proposes to do is for the actual pipeline structures, it proposes a setback of 500 feet, which should be from the property lines. That property line setback can be waived by affected property owners. The second setback would really be the above ground structures. And again, I won't go into the terms of all those, but essentially they're just the above ground structures. That minimum setback would be 1,320 feet from a structure or from a dwelling, a church, a school, or a business. Again, that setback can be waived by an instrument filed with the Register of Deeds, which we typically do with concentrated animal feeding operations, or the easement that's signed by the landowner and the applicant. The third setback would be that no pipeline or above ground structure can be located within that municipal jurisdiction, the platting jurisdiction. So as you're aware, is that municipalities in the county or any municipality in the state can file a major street plan with the county and then enforce platting jurisdiction outside of their corporate limits. So this would prohibit locating those pipelines or above-ground structures within that jurisdiction that's been established by the municipalities. And then the application requirements, all different types of materials submitted to the Planning and Zoning Department would be reviewed. If at any time the Planning and Zoning Department felt that the setback wasn't sufficient as defined above, we would have the ability to recommend to the Planning Commission an increase of that setback. As far as other requirements, the Planning Commission did propose a fee to be associated with the carbon oxide pipelines, and that would be $5 per lineal foot of pipeline within the county. And then they also wanted an escalator so they just didn't stay static with the fee structure. So commencing on January 1st of 2026, it would increase by 2.5%, and then every year thereafter. Another item would be the depth of cover. So there was concern with the public that there wouldn't be sufficient depth of cover. This ordinance would establish that the minimum depth of cover would be 7 feet for a pipeline. And then the landowner would not be responsible for maintaining that depth of cover. It would be the responsibility of the applicant or their successors. And then the ordinance also proposes to modify the notification process, and this is for all conditional use permits. But more importantly, it would establish a 2-mile notification requirement for carbon oxide pipelines and above-ground structures. And then the last item would be, as number 3, is that all notification costs shall be covered by the applicant. So I did point this out to the Planning Commission that when it does get appealed, that the county bears that cost of appeal notifications. And so with this ordinance amendment, that would change that to the applicant would cover all costs that would be involved with notification. So again, in summary, is that this is proposing to make carbon dioxide pipelines and above-ground structures conditional uses. As you're aware, conditional use permits in Lincoln County are heard and decided by the Planning Commission after a public hearing. If at such time, within 5 days, if there's any appeal that would be filed, then that would come before the Board of Commissioners. So that's essentially the substance of what the ordinance proposes. With that, Madam Chair, I'll turn it back to you and certainly answer any questions at this time or later if the board may have any.
Well, thank you, Toby. Any of the board members have questions for Toby? All right, if
Thank you.
not, we'll move on to proponent testimony. Proponent's testimony will be limited to 30 minutes total time, so it won't be on an individual basis, it will be as a collective group. So if there are proponents who want to come up and speak, now would be the time to do so.
Do I need to give address?
What's that, Tony?
Do I need to give address?
Just where you live.
Okay. Tony Ventura, 47763, 292nd Street, South Dakota, 57034. I would like to thank Commissioners Odom and Putnam for planning and zoning. They have done an exceptional job in putting together an ordinance that protects our county and landowner rights. They used common sense and made necessary adjustments to keep the ball rolling to develop this ordinance. You will be asking at this point, well, who showed up at the last planning and zoning hearing to this ordinance to oppose it? The answer is nobody. No other county commissioners from Betty Odom, no representatives from the pipeline company, no lawyers, no one. Another issue I have is there's been false statements floating around if we can't build in these areas because of these maps that are being produced. They're showing fake numbers and fake science. Got a page stuck, I apologize. But everyone knows here that waivers are in place and anything can be built with waivers. But landowners are not always willing to sign waivers when companies are not transparent, fair, and truthful. It was stated by someone on this board that a place in Texas built a pipeline close to a school. Since when is our county fair game for rules passed by another state? Their bad planning and zoning and development should never dictate to us what our county should do. I have worked on getting an ordinance in place for years, and I know smart development always brings in good results for the county. Just know that no ordinance passed, the PUC can override us and bring a pipeline in. That's why this is so important to have. One last thought. A significant piece of this ordinance is making setbacks to the parcel line. By incorporating this language, you save the county hundreds of battles in the future as you stand to preserve the rights of all landowners on both sides of the fence. I believe it's imperative that you pass this ordinance as is today to protect the citizens of the county. I also have letters from the mayor, signed letters from mayors asking for these setbacks and changes, and townships. Thank you.
Thank you.
Linda Montgomery, Fairview, South Dakota. I'm going to read a letter from Sarah Stever from Lennox, South Dakota. Commissioners, thank you for your time today and for your time over the last few years as we have worked to find a fair and reasonable ordinance for siting CO2 pipelines. I wish I could be there today. This is not a perfect ordinance from my perspective, but it is a compromise that we should all agree supports the orderly and efficient growth of Lincoln County. Measuring from pipeline to the property line is key for orderly and efficient growth. It is important to acknowledge that it does not prevent a company that acts in good faith with our residents from building a CO2 pipeline because they can negotiate waivers with any landowner. If you've seen the proposed route maps, you can easily recognize the pattern of a company that does not act in good faith, but it puts own interest over those of the people who are forced to live with and try to develop property around poorly sited pipeline that will forever be in the ground. This ordinance creates transparency for residents by giving them access to all information, funds, emergency responder equipment needed into the future, and allows for monitored farming and agricultural practices to happen unimpeded. I also want to thank Planning and Zoning for their work in creating and unanimously passing the ordinance. I hope the commission will pass this too. And I ask you today to please pass this ordinance without amendments. Respectfully, Sarah Stever. And I, Linda Montgomery, want to say me too to this letter. Thank you.
Anybody else?
Good morning, Scott Montgomery, Fairview. I just ask you to pass this order as written. This has been going on for a long, long time, been a lot of battles over it, and been a lot of time and effort spent on this thing, and I think we've got an ordinance that is good for the county, and I think that's what we need to do, is pursue what's good for the county. Thank you very much.
Any other proponents? All right, if
Madam
not,
Chair, did you want me to read that?
if you want to read it, you can, or you can certainly have somebody in the audience read it.
I can read it.
Okay, go ahead.
I have a proponent letter from Representative Carla Lems. She sent that to all of the commissioners up here, and I also printed a copy for each one of them. Dear Commissioners, I am extremely grateful that the Lincoln County Planning and Zoning Commission has passed an ordinance for a CO2 pipeline. Moving forward with this ordinance was key to providing substantive protections to the people of Lincoln County. As you know, I have been very involved in listening and learning from the people across the state regarding concerns about CO2 pipelines and their impact on private property. The state legislature recently passed HB 1052, which does not allow for eminent domain to be used for a CO2 pipeline in South Dakota. However, this does not prevent this present project or future companies to continue to pursue CO2 pipelines in this state. That is why it is imperative that counties take action to implement regulations and setbacks to protect Lincoln County citizens' interests. This ordinance has literally been in the works for years. Again, I am thankful to the P&Z board for passing this unanimously. The ordinance as proposed works well within Lincoln County Comprehensive Plan for Strategic orderly development. Another positive effect of the ordinance is that it does not prevent a property owner from doing business with a CO2 pipeline company, as a waiver can be negotiated. Important to note is the following: setbacks should be to the property line. Plume models should be presented upon application. $5 per annual fee is essential to protect the county from additional expense. Minimum depth of coverage of 7 foot necessary with South Dakota weather conditions. 2-mile notification informs citizens of upcoming meetings, and good communication is good government. Thank you for your service. I respectfully ask that you pass this ordinance as is. Respectfully, Representative Carla Lems, District 16.
Thank you. All right, any other proponents? All right, if not, then we'll move on to opponents. If there are any opponents that would like to speak, now would be the time to come up. And it will be the same 30-minute block. All right, not seeing any, then I would close testimony. Any discussion amongst the commission?
I do, Madam Chair.
Yep, go ahead.
This has been 2.5 years in the making, a lot of public testimony, and huge thank yous go out to the people of Lincoln County, because this commission, the planning and zoning, and the public were all involved in this. This was a grassroots-driven ordinance from day one. We did listen to what people wanted in Lincoln County, and not only did we listen, but we acted by putting this ordinance together. The vernacular never changed, using the property line for the setback. Lincoln County is the leader for landowners' rights. SB 201, the so-called Landowners' Bill of Rights, was referred with 17,500 required signatures. They received 31,432 verified valid signatures, which goes to prove that this was across the state, and we're very concerned about landowners' rights. This ordinance, again, had no opposition from any public or any business, so we're asking for a unanimous vote today to pass this ordinance. Governor Roden just signed the bill into law, preventing carbon solutions from using eminent domain, which is huge. Then they put in a request to the PUC, which they are meeting today, that they wanted to pull back their request to move forward with their pipeline. So PUC is supposed to respond to Summit again today. So again, I also want to, again, thank everyone that was involved in this, including former Commissioner Jim Gibbon, who was chair of the Carbon Dioxide Transport and Storage Advisory Committee, and the other citizens that were involved in that, to bring that forward. There were 4 other ordinances brought forward, and this is the one that they passed unanimously. It was a 4-0-1 vote. I abstained because I would be hearing this again in the commission. So thank you, Madam Chair.
Thank you. Any other discussion amongst the commissioners?
Madam Chair? Thank you, Commissioner Otten and Doug, for bringing this forward. I want to give a shout out to a gentleman who's sitting in the back, Tony Ventura, who has been a tireless individual who has committed the better share of his life to this thing, having gone to Pierre. And Tony, thank you. We may not always agree, but I do respect your commitment to these kinds of activities. We have wrestled with this thing, as Commissioner Otten has said, for 2.5 years, and this thing has gone over and over and over again. So it's time to put this thing to bed. It's time to put this in the past. We have many challenges here in Lincoln County which we're going to have to deal with in the future. And this is one that now has been pretty well muted across the state, as has been stated about the eminent domain being not relevant anymore, not being used anymore. There are concerns that I do have talking to the commissioners from Lake County, where they have not passed an ordinance and they have refused to do that. So now there is a citizens group that is going to force this to a public vote. They are collecting signatures and they probably will get this. And theirs isn't going to be an ordinance like this one in front of us today. It's going to be a flat blanket, no, we don't want a pipeline in Lincoln County or in Lake County, period. So in lieu of that, I don't think that we as commissioners should force our citizens to have to do that. I think we have something here that I may not always agree with. There's not all of this stuff in here that I necessarily support. But on the other hand, you got to weigh the public good. So what my personal bias is versus what this ordinance is, to put that in front of the entire public, or our entire county, I think I'm going to vote in support of this thing. I want to get this done. I do think in the future, I wonder where the federal government will be. I wonder where a lot of things will be. If Summit Carbon goes away, will there be another proposal coming in? Will the federal government mandate this thing which supersedes all of this? These are the unknown things that are out there. I'm not that concerned, but right now, Madam Chair, I think this is an ordinance. It isn't perfect, as Sarah has said. In talking with her, we have some agreement and some disagreement on that. But overall, it will put something in place that I think the public will appreciate and support, and we can move on to other issues that we need to do. Thank you.
Thank you. Any other discussion amongst the commission?
Madam Chair,
Yep, go ahead.
thank you. Good morning. Tony Ventura's done a lot of work on this, and good thing about working with Tony is even though maybe we don't agree on everything, we were always able to shake hands at the end and respect each other. And I think that's important in today's unfortunately politically polarized climate that we find ourselves in, is unfortunately that when people disagree with each other, they think it needs to lead to fisticuffs or throwing Molotov cocktails at Teslas or fighting each other and things like that. And we need to get back to shaking hands and talking to each other and working with each other even when we disagree. My concern, so thank you, Tony, for being very civil and for also being a very zealous advocate of the pipeline ordinance. But this is where we're gonna have to agree to disagree. And I want to do it in a civil way that sets an example for people across this state to be able to disagree in a civil manner without calling each other names, but sticking to the issues. And my concern here is paragraph C, which is the application requirements, in particular application points C1 and C2. And paragraphs C1 and C2 of the proposed ordinance talk about plume modeling and very specifically require the county to take certain actions and do certain things on the basis of safety. And counties are not permitted under the United States Constitution to regulate pipelines on the basis of safety. There's a pretty well set doctrine of law out there. It's called the preemption doctrine. And I've noticed recently there's a lot of people in this state, and I appreciate them, who talk about wanting to protect and defend the Constitution. And we have to embrace the Constitution, the parts we like, but also the parts we don't like. And sometimes one of the parts that opponents of pipeline, proponents of pipeline ordinances may not like in this instance is what's called the preemption doctrine in the Constitution. You know, there's parts of the Constitution I like. I love the First Amendment, Second Amendment, I love it all. But there's also another part that probably will confound people, and they'll say, well, how come the Constitution can do that? Well, there's this thing called the preemption doctrine that says when the federal government has regulated an area or field of the law to such an extent, it means that subordinate units of government, i.e. states and counties and cities and townships, cannot regulate that area or field And in this instance, I believe that the law is very clear, and so is the case law, and so is that case from Iowa where the county commission wanted to do this, and the district court judge told the county they couldn't do it. Now the case is on appeal to the Eighth Circuit Court of Appeals. And I think in this instance here, unfortunately, I can't vote for this because of the plume modeling, because it's based on safety. So I'm going to follow the Constitution today, and I'm going to vote against it. And quite clearly, I don't have the votes to amend this. Otherwise, what I would do is amend that section out of it. And here's the other thing I do want to say for the record. There's a lot of things in this ordinance that I do like. I like the depth of cover issue. That's a good provision. And it's good that the pipelines voluntarily agreed to accept those depth of cover issues too in our discussions with them. Another issue is the setbacks. Setback is good. But again, why is there a setback? Usually it's for safety issues. One of the other concerns I have is that if you have different diameter pipes coming from the state of Iowa, and then you have a smaller diameter pipe here in Lincoln County, like let's say, for example, the plume modeling says you can't have a 20-inch mainline pipe. Let's say it only says you can have a 4-inch mainline pipe. Well, the law of unintended consequences is going to kick in, and then the question is going to become, how do you connect a 20-inch pipe from the state of Iowa to a 4-inch pipe in Lincoln County? And then what happens when the 4-inch pipe hits the Minnehaha County border, and Minnehaha County doesn't have a provision or prevention on the size of the pipeline, and then it jumps back up to 20 inches. So I have concerns about the law of unintended consequences there as well. Lastly, I think the proponents of this ordinance have been very zealous, and they want to protect their families and they want to protect their community, and I appreciate that. But I think that there is a constitutional way to do that. There's an unconstitutional way to do that. So I respectfully will not be voting for this ordinance. Thank you.
Thank you. Any other discussion amongst the commission? All right. I'm just, this is such a controversial issue, more so in the southern part of the county than perhaps the northern part of the county. But I do have to agree with Commissioner Aaron's comments on pretty much all levels. One thing that's always been a really big concern to me is preventing somebody from doing business in Lincoln County. And if this ordinance, if it passes today, does in fact do that, it subjects us all to a lawsuit. And as attorneys know, lawsuits involve a lot of money, potential payment of damages. And when you look at the amount of damages that the county and the taxpayers of the county could be held to for preventing somebody from doing business in Lincoln County, if this ordinance in fact does that, I hope all these people in this group are here to support the fact that all the taxpayers of Lincoln County will have to pay that bill if that comes to fruition. And I think that's something that maybe hasn't been considered, is, as Commissioner Aaron's pointed out, unintended consequences of something that we do. And so this probably makes everybody feel really good, which, great. We like to do things that make people feel good, but those unintended consequences sometimes are not what's in everybody's best interest. So for those reasons, and the constitutional issues that Commissioner Aaron's brought up, I'm not going to be voting for this today. There are parts of it that I like, but again, there are parts of it that I just can't support. So with that, if there's no further discussion, I'd consider a motion.
Motion to approve.
I've had a motion and a second. Any further discussion amongst the commission? All right, if not, Alicia, will you go ahead and call the roll?
Commissioner Aaron's?
No.
Sorry. Commissioner Otten?
Yes.
Commissioner Schmidt?
Yes.
Commissioner Putnam?
Yes.
Landine?
No. Motion carries. All right, next item on our agenda. Thanks for coming, everybody. Next item is notice of Good Earth Farm bingo per SDCL 222525.
Yep. So Paul Anderson, Commission Assistant. I am here for, we have a slightly new process that was created by the state's attorney. So in the past, you've just seen a notice per it. This is going to be a little bit more standardized form. So it'll have a bunch of stuff and everything can be filled out. So thank you, Drew, for putting that together. So this one is for Good Earth Farm to host a bingo on Wednesdays in June, July, and August. The Good Earth Farm is here to answer any questions if you have them. Otherwise, no further action is needed by the board unless the board would like to request or would like to pass a resolution of objection.
All right, anybody have any questions for staff? Or for the applicant? All right, and we don't need to vote.
Right.
Okay, perfect.
Thank you.
Move on to our next item. Actually, you know what? I'm gonna circle back and ask if there's any public input on that notice before we move on. All right. Next item, board action on application for abatement. Morning.
Good morning, Madam Chair, Commissioners. Carla Gosen, Lincoln County Director of Equalization. This morning, you have before you a request for compromise abatement under South Dakota Codified Law 10-18-2. The County Commission may abate or refund taxes under specific circumstances. Subsection 4 addresses situations where a loss has occurred due to flood, fire, storm, or other unavoidable casualties. This request pertains to parcel number 200.60.00.001 owned by Creekside Associates LLC, which is seeking an abatement due to damages sustained during the June 2024 flood event. Today, I'm asking for direction from the commission on how to proceed. So are we willing to consider a compromise abatement for specific components of a structure that were affected? Or are you open to considering an abatement in the event of a complete structural loss, which has been the precedent in previous cases? In this case, the business was shut down for 5 days following the flood. However, full HVAC functionality was not restored until mid-September, which raises the question, should we abate to cover the 5 days of closure? Should it extend through the 3 months until the HVAC system was operational? Or should it reflect some other duration or scope, which would be the guidance from the commission? Additionally, is the commission open to considering an abatement for maintenance and repair costs that is directly tied to the unavoidable casualty? Before the Director of Equalization can issue a formal recommendation and before our legal team can review it and the auditor can calculate the corresponding tax loss, I need some direction from the commission. So Commissioners, the question before you are, do you deny this abatement request today based on existing precedent? Or do we place it on the agenda for May 6th for further consideration? If you choose to move it to May 6th, I ask you to please provide clarity on how many days we should abate this for, what components of the property or operations are to be considered in the abatement.
Anybody have questions for Carla?
I have one. Was there any insurance involved in this, like flood insurance, insurance on the HVAC and stuff like that?
I believe that's in your packet, and from my understanding, there was, because of their, and I don't know if the applicant is here today, I believe the insurance was denied because they didn't have flood insurance coverage.
Thank you.
Carla, I seem to recall that at our last Board of Equalization meeting, we discussed the dental office, and we did give them some relief. Is this a different property?
They're seeking abatement for 24 taxes, pay 25. During the appeal hearings, it's the 25 value, pay 26.
Okay.
So yes, it is different.
Okay.
But it's been accounted for.
For the 25 assessed valuation. They're seeking the 24 tax relief.
Yeah, I think, okay, so basically, they want us to go back in time to the date of damages and give them retroactive property tax relief for the loss of use and enjoyment of their property. I got that part.
Okay.
And then what we did the other day is we gave them some relief on the basis of the fact that they've lost some usable space in their building.
Yes, and also for the,
Use as defined by them in the form of
Correct.
loss of patient rooms.
yeah.
Yeah, okay.
And we gave the prospective credit for the HVAC.
That is
We've already
correct.
done it,
Yes.
Yeah.
so. I guess
The init-
I'm not gonna support it, and it's a slippery slope.
It's very, yes, I agree. My initial recommendation was to deny it because, there's many times that a storm can occur and you take your shingles off and are we gonna start abating shingles and
Carl,
siding?
aren't we
and-
setting bad precedent here? I mean, when you have a flood, a flood is a flood, it's an act of God or something like that. And if we begin this, like you say, we have opened Pandora's box to just about anything from anywhere, from anybody across the county. So I'm not in support of that.
And this is why it's a compromise abatement, commission hears them, they can, they may abate, it's not a must. It's,
So Carla, just could you maybe walk me through the process of how this even got on the agenda? I mean, I understand you put it here and everything, I got that part. But can any citizen just walk in and file for a retroactive abatement like this, and then we
Yes.
have to hear it?
yes,
Okay, all right,
yes.
okay, all right.
Pretty open.
So I just want to be clear, I mean, I understand the slippery slope argument here, but the reason I asked you that question is the slippery slope is already permitted by law. In the sense of, anybody can come in here, make application, and it has to be heard by us. But we don't necessarily have to approve it.
Correct.
So maybe this is more educational for me, but also for the members of the public, so they understand. Anybody can walk in and file for an abatement, and then we have to consider it.
Yes.
Okay, thank you.
Any other questions for staff? All right. Any public input on this agenda item? All right, if not, can I get a motion, please?
I move to go by what the Director of Equalization recommends, and that's denial.
So your motion is to deny the application for abatement?
Correct.
Thank you. Is there a second?
I'll second.
Got a motion and a second? Any discussion amongst the commission?
I wish these folks would have came in and maybe made a little bit narrower application that, because I think the action we took the other day took into consideration their, the HVAC issue. And I get the sense that maybe there's a little bit of double dipping here now. But I don't know.
I don't necessarily consider it double dipping because what you heard last Tuesday was based on the 25 assessment payable 26. They're requesting an abatement, like you said, to go back proactively for June of 24 and moving forward.
Okay.
So last year's tax.
Okay.
It does seem kind of like a double dip to me too, because even though it was a 24 loss, we took that into consideration in the 25 value,
Yes, you did, yes.
so. All right, any further discussion? If not, on the motion to deny, Alicia, will you call the roll?
Commissioner Aaron's,
No.
Otten,
Yes.
Schmidt,
Yes.
Putnam,
Yes.
Landine.
Yes, motion carries. Application denied. All right, next item, board action to approve the highway department to purchase off a Brooklyn County bid for culvert lining. Good morning, Terry.
Morning, Board. Terry Floyd, Lincoln County Highway Superintendent. Looking today to purchase off of a Brookings County Highway bid for culvert lining. We have 3 structures that we're going to be lining this year, hopefully, if we can do this, so. And the bid will be with Subsurface. And again, that's in the bid packet.
All right, maybe a question for legal counsel, but do these even need to come before us? All right.
Because of the cost.
Gotcha. All right. Is there a motion? Or, well, public input first. All right,
Move to approve.
thank you. Is there a second?
Second, Otten.
Thank you. Alicia, will you call the roll?
Commissioner Aaron's,
Yes.
Otten,
Yes.
Schmidt,
Yes.
Putnam,
Yes.
Landine.
Yes, motion carries.
Thank you.
Thank you, Terry. Next item is board action to approve the reclassification of the IT specialist position to desktop analyst. Was Carrie gonna come up for this? Oh, I have Jay.
Director will.
Hi, everybody.
Hi.
I'm here in Carrie's place because she is out, but I am seeking authorization to change the IT specialist position to a desktop analyst position so that we can start recruiting for that position that is open. With this reclassification, there is no changes to the 2025 budget. The reclassification actually lowers the grade, which will also lower the amount that the county has to pay.
Like the sound of that.
Yeah.
Anybody have any questions for Jake? All right, any public input? All right, if
Move
not.
for approval, Madam Chair.
All right, thank you.
Second,
Got a-
Otten.
Got a motion and a second. Alicia, will you call the roll?
Commissioner Aaron's,
Yes.
Otten,
Yes.
Schmidt,
Yes.
Putnam,
Yes.
Landine.
Yes, motion carries.
Thank you, everybody.
All right, next item, board discussion and possible action to schedule a Board of Commissioners regular meeting in the evening. So we've had some requests from the public to do this and, off and on through the years. And so I thought maybe it was a good idea to look at it and wanted to get the commission's kind of take on whether that's something the commission would want to do. I checked with department heads and they all appear to be able to manage their scheduling so that it would not increase our overtime, wouldn't lead to overtime hours for staff and what have you. And I've been assured that that will not be a problem. So just as a starter to see how it goes, thought maybe we could do one of our 3 meetings a month at night and try it out for 6 months and see how that goes. And if we do see, greater attendance and greater participation from the public, that maybe then we could consider moving that forward into the future. So just want to get the commission's thoughts on that and if there's any inclination to take action on doing something like that.
Madam Chair.
Yeah, go ahead.
I think this has been a long time in the making. I think in the society we live in now, most folks obviously work from 8 to 5. When I first got on the commission, I was surprised that we do these meetings during the mornings. Just for the public's edification, apparently, and not that I'm going to stand on tradition or anything, but apparently almost everyone around South Dakota does these county commission meetings on Tuesdays in the mornings. Not all, but a supermajority do, probably well above that. I assume the reason probably why is because sometimes these county commission meetings can be very staff intensive. And so the staff is obviously here from 8 to 5, and you need to have the staff here to help make decisions, et cetera, et cetera. But at the same time, we need to balance that with availability to the public, because the county doesn't exist for the benefit of the staff. Although, that is one of the considerations and equities that we have to look at. Government's for everybody, not just for the people who work here. And part of being transparent means you've got to do things outside your comfort zone, and that means having meetings at night. It's not like this is an oddity, because when you flip the other side of the coin and you look at city councils around South Dakota, almost every single city council does their meetings at night. So it's not as if government can't manage this. I think it's easily resolved. I've got a couple different courses of action. I mean, number one is you just flip the whole thing to do every single meeting at night, just like city councils do. Maybe that's biting off a little more than we can chew right now. I don't know. Another course of action, though, is like Commissioner Landine said, you do one of the 3 meetings a month. But what I would bootstrap onto that is that we do all public hearings at the nighttime meeting. So in terms of scheduling and logistics, if there's any kind of action that needs a formal public hearing, like today with the pipeline, I'm sure there's people who wanted to be here today to express their sentiments, but they can't because they got to be at their job to support their workplace and their families. And so maybe we do one of the 3 at night, but what I would suggest is we attempt to have all public hearings at the nighttime meeting, because it just stands to reason and common sense that that's when people can get off work and want to participate. So those are my 2 cents.
Thank you, Commissioner Aaron's. Anybody else?
Yes, I would like to see it actually like 2 times a month I prefer. I think more people, there's been so many people that say they want them at night, so, I would go for 2.
Madam Chair?
Yeah, go ahead.
Well, I think this is long overdue, and we can chase this rabbit around. Yeah, we should have meetings at night. Just because I've had a privilege of being around a long time, there was a time when we did try that. We did have meetings at night, and no one came. And, but that was when Lincoln County was much smaller, not about approaching 80,000. I think we were close to 8,000 at the time. So an evening meeting, 1 meeting a month certainly doesn't hurt anybody. It gives a good opportunity to see whether or not you will have the kind of attendance. I would hope that we could, in an evening meeting, we could engage more of our citizens in the north that probably aren't as actively engaged in Lincoln County activities as they should be. So the other thing that I would propose for us to think about is that we take this traveling roadshow and we actually go to the city of T or Harrisburg or Lenox or Sioux Falls or Hudson for that matter. I'm not opposed to going down there either. But I mean, we could localize this whole thing, and we may not have the official meeting.Maybe it's a listening meeting. Maybe instead of a full-blown thing and having people come at night and listening to Terry wanting to buy, a culvert from on Brookings County bid, maybe we have a subject that is of great concern to overall Lincoln County. Maybe we do more information on our comp plan. I think the public would have really benefited if they would have listened to the department heads coming in and learning all of the intricacies, for example, our sheriff, how many miles they travel, what their caseload is, or you listen to the state's attorney or any of our department heads, which would give the public a chance to really understand how hardworking the staff is and all the different things that they have to do. I think there would be an appreciation of county government a lot more than probably a lot of people know, or not criticizing them for not knowing, but it would give them an opportunity. So I'm all in favor. So when do you want to start?
Madam Chair.
Go ahead.
I totally agree that I agree with Commissioner Schmidt and Commissioner Landine to try the 1 meeting a month for 6 months. But for Jim's suggestion to go to other localities, it doesn't really work because there's no IT to video it, to put it online. So you'd have to have a room here to be able to video that. You could do the other ones as informational meetings, but it wouldn't be taped. So I'm still with the one night a month for 6 months to see how that works.
You know, yeah, and I like Commissioner Aaron's idea of doing the public hearings at that evening meeting. So more people can attend. Or if there's something, you know, we usually kind of know what the hot button topics are and maybe can put those on that night meeting if we need to. So if there's a consensus or a thought to doing that, I would just, you know, we'd need to discuss like what time they would start. Folks in Sioux Falls are getting off work at, 5 o'clock, get the traffic, get home. Maybe they gotta let dogs out or who knows? I have to go let dogs out. So, want to give people enough time to get those things done too if they're going to drive down here to Canton for a meeting. So what would the thought be on a start time? Would we do 6:30, 7?
I'd say 6:30.
Okay. Anybody else have thoughts about that?
I was gonna say 7 o'clock, because by the time people get home, if they got a family, if they gotta have an evening meal, if they gotta change, I don't know. I just think 7 o'clock is, and I don't know, that just seemed like a logical time, but
Well,
I'm
why
open. I'm
Well, planning and
flexible.
zoning is at 6:30.
Yep, the P and Z are at 6:30.
How about 6:45, Commissioner Otten?
Well, I'm just looking at public hearings can take a very long time, and if you don't start
Yeah.
until 7 o'clock, you might be here a very long time.
Why don't we do this? Why don't we try the 6:30 slot, and then this is kind of a trial run to see how this goes. We can always change it if we think that's too tight,
And then
too much of a
what
time
night?
crunch. I would say the Tuesday night. And I don't know if that's gonna butt up against any of our other obligations, but like I said, we can,
You wanna do the last meeting of the month? Would that be the best time?
the last Tuesday of the month.
That coordinate with our public hearing.
Yeah.
Yeah, that would,
'Cause
yeah,
that's when their hearings are.
okay. Last meeting of the month, starting at 6:30. All right, can I get a motion?
So moved.
Second.
Got a motion and a second. Any more discussion? I forgot public input. Any public input? Sorry, folks.
Here's your chance, Scott.
Scott Montgomery Fairview. I want to thank all of you for being so open-minded and hope it works out. I know, I guess the only way to find out if it works is to try it, and I appreciate you being open-minded. Thank you very much.
Thanks, Scott. Anybody else?
Is that motion, sorry, is that to start next month? Sorry,
I guess we didn't say, so I would say yes, because we're already gonna be here. We're here right now, and we're here next week.
Really enjoyed today's meeting, and I thank you for your open-mindedness on giving the night meetings a chance. One of the things I want to throw out there is, just for time for everybody involved, you guys, the public, everything, is there any way that could be changed to where these meetings only need to be held twice a month instead of 3 times?
We are held 3.
What's that?
We are held 3.
I know, you're held 3 now, but is there a way we could cut it back to where it's only held twice and get all the business done in less time, so everybody has to make less trips? I just want to throw that out there. Thanks for your time.
Thank you, sir. Can you just, for the record, state your name?
Mick Baruth, Sioux Falls, South Dakota.
Thank you. All right, any other public input?
Linda Montgomery, Fairview, South Dakota, thank you. I appreciate you making this motion, and I thoroughly agree with Commissioner Aaron's on having the public comment report, the public reports at that time. I would like that to be part of the motion. Thank you.
Thank you. Any other input? All right, any other discussion amongst the commission?
You know, Mick, there is a county commission out in the far west, northwestern part of the state that only meets 2 times a month.
That Harding County?
Yeah, there isn't a lot going on out there. No,
Yeah, I think
no
there's
offense
about
to
20
those.
people in the county.
No offense to those
county.
folks.
Alicia, you call the roll, please.
Commissioner Aaron's,
Yes.
Otten,
Yes.
Schmidt,
Yes.
Putnam,
Yes.
Landine.
Yes, motion carries. This would start in May. All right. And then we need board discussion and action to establish a committee to recommend alternatives for the old courthouse. Commissioner Schmidt?
If you drive by, you'll see the new Justice Center taking shape on the western part of our western side of Canton. So what are we going to do with the old courthouse? Because when the court system leaves and everything and they lock the door, what are we going to do with that structure? And that's going to be something that will be emotional for some, as what are the options? So I think it's high time that we get ahead of the game rather than trying to be remedial here. And we form kind of a committee that sits down with various members of the community, a couple of commissioners, and we take options. We look at the cost of maintaining the building. We look at the cost of perhaps removing the building. If you do, what are the options to replace the facility out in front? Is it a community meeting room? I think there are just all these options that have to be explored and brought to the public and give everybody an opportunity to voice their opinion on what they think should be done with it. And we quantify it with our impact on the budget and what the cost is going to be. So in a nutshell, that's kind of a very simple thing, not to belabor it, but I don't know that you need a whole series of maybe 2 or 3 or 4 meetings. And you invite all kinds of public input for individuals, and we come back to the commission with some recommendations and action that can be taken. So that's what I'm requesting.
Commissioner Schmidt, I appreciate you bringing this forward. I know that you and I talked about this, a couple weeks ago?
Yep.
Fully support it. Just so the public knows and the rest of the commission, myself and John Rombo, who's our facilities director, he and I have been meeting for the last few months to talk about this issue. Just very high-level initial conversations, no granular level details. But we've just tried to internally start this conversation talking about, okay, once the court system, as well as the state's attorney's office, vacates this building and moves over to the new courthouse, we're going to have a lot of space available. And some of that will be filled up by the existing folks who are here. And then some of that will may for a period of time remain vacant because it's just more space available than what we've had the need to fill. And I know that John Rombo, Commissioner Schmidt, he's been going around talking, just starting again, very high-level discussions with department heads to try to figure out what their future space needs are, what their current space needs are, trying to get a handle on that. But I think the larger issue you're bringing up, Commissioner Schmidt, is getting the public involved and grappling with the potential that we need to figure out what to do with the old courthouse once it gets vacated. There's a couple courses of action, right? Pay a bunch of money and knock it down. Or pay a bunch of money and rehabilitate it. But we don't know how much each of those options is going to cost the taxpayers. So we've got to get the public involved, get the key stakeholders at the table, figure out what they want to do, and then we'll have to get some estimates to figure out what it's going to cost to do all those things. And believe it or not, you have to pay people to get cost estimates now. So you can't just get a free estimate from an engineering company or something like that. So there may actually be a need for this commission to have to approve the expenditure of funds just to figure out how much money it's going to cost. So that is something that we have to figure out if the public wants to do that as well, because property tax dollars are sparse these days. So thank you for bringing this forward, Commissioner.
And Commissioner Schmidt, how are you going to involve the public? Are you going to do it like we did before and just request people to send a name in? Because I think that Chad would be
I tell you
excellent
what,
on that.
Betty, it's kind of a work in progress. I was going to say that I would have another commissioner, and I would like to have Commissioner Aaron serve on that because he is the liaison with John Rambo. And he and I would sit down and we'd come up with a game plan on how to engage people from Canton, from Hudson, from Fairview, from wherever, Sioux Falls. Try to get as much as you can and come up with, and lay this out. Because this is kind of a work in progress, as I said, and you're trying to be as encompassing as you can. So there's a lot of details that have to be worked out. So I would like to have Commissioner Aaron's and myself set the parameters of this thing, and we'll come back to you and just tell you what we've gotten done.
Yeah, and I think, we obviously welcome invitations. Somebody wants to be a member of the committee, give us a shout.
All right, any public input on this agenda item? If not, is there a motion?
So moved.
Is there a second?
Second.
All right, I got a motion and a second to establish a committee with Commissioner Schmidt and Commissioner Aaron's figuring out the parameters of what that committee looks like. Any more discussion? All right, Alicia, we call the roll?
Commissioner Aaron's,
Yes.
Otten,
Yes.
Schmidt,
Yes.
Putnam,
Yes.
Landine.
Yes, motion carries. Next is our opportunity for public comment for items not on the agenda. Anybody that'd like to come up and address the board about services or policies, now would be the time to do so. All right, any commissioner reports today?
Madam Chair?
Yes.
Paul's going to put up a sheet. We met, Commissioner Schmidt, Putnam, and I went to the South Dakota Association of County Commissioners April 9th and 10th. On the first day at 10 o'clock, we had a cybersecurity program, and Jim Edmond was one of the speakers, but also it was Shane, I don't know how you spell his or how you say his last name, Hoken, cybersecurity advisor, and also Mike Waldner from DSU. He was there. Mike was brought back because he was instrumental in setting up the K through 12 email program. All three of those had the nicest things, the most wonderful things to say about Jake Oakland. And so I wanted to bring that to the public's attention, that he is known throughout the state as being one of the best IT directors in the state. And so I just wanted to bring that forward and commend Jake for that.
Thank you for that. Any other commissioner reports?
Madam Chair.
Yes.
On Thursday, April 3rd, thanks to the Sioux Metro Growth Alliance, they set up a roundtable discussion with myself, two county commissioners from Minnehaha County, as well as city officials, mayors, city councilors, and other city administrators from both Lincoln and Minnehaha counties. And we met with Governor Roden, and the topic of the meeting was to talk about property tax reform. And I just want to report back, and we had Paul Anderson, our assistant there as well, and I want to thank him for helping set that up too, because he was working some of the logistics on it. But getting to the guts of the meeting, folks, the governor wanted to solicit feedback on this issue of his proposed property tax reforms. And I won't mince words here, folks, but a lot of the folks in the room want more revenue and don't want to make cuts. And Paul can vouch for me here. I challenged the governor on this issue of property taxes. And I told him Lincoln County needs property tax relief. And I also told him that some of us are willing to make cuts as well. So we had the meeting. It was rather enlightening, and I'll just say that there's some different perspectives out there. Thank you.
Thank you. Anybody else?
Madam Chair, just for National Association of Counties is our national organization. And they do a lot of lobbying in Washington, D.C. And we had a board meeting the selected board meeting, I should say, dealing with the new farm bill that comes out. And there is a huge amount of, monies that come not directly to the farmer, but goes for food and go for economic development. In fact, the majority of a farm bill monies, contrary to what people believe, does not come in form of subsidies to farmers. It goes for food and economic development. Well, one of those is this Food for Kids on programs, and that's been earmarked for a severe reduction. So there was a lot of conversation about the impact on how these programs that are designed currently to be funded by USDA or by an ICAP agency. An ICAP agency that comes around and they take care of Meals on Wheels, they take care of Head Start, they take care of weatherization, they take care of all kinds of programs, and those are now all have been severely either cut out or they have been severely reduced in their amount of money available to them. So if you look at county government, not for a listen, but county government, when it was conceived back when we were a state, counties were the bottom, they were the support. They were the safety net for all of these kinds of activities, for rent, for food, for everything. And if you check back, you'll find that many of our commissioners went around and took the temperature of people and actually brought things to various people back in the 1930s and in that area. Well, the point was, briefly, is how much impact this will have on county government to act as that safety net. And that was the point of discussion, to say, what are your budgets, how much money allocated for these various things? And if those activities are not there performed by these current agencies, who then, will we let them fall apart? What will be the reaction? How will we handle, individuals who are unable to travel and move food? So it was a very broad-based discussion, but an eye-opening one. But it's something we're going to have to look at. And our challenges of revenue for our county government, it's going to be a challenge for us. And as Commissioner Aaron said, if there are cuts made, where do they go, and that kind of stuff. So that's why we got some challenges out here, folks, and we're going to spend a lot of time, I'm sure, just debating that.
Thank you, Commissioner. Anything else from anybody? All right, if not, do we need an executive session, Drew? Nope, all right, then can I get a motion to adjourn?
So moved.
Second, Otten.
Thank you, got a motion and a second. All in favor, say aye.
Aye.
Aye. All opposed? All right, we are adjourned.